Lordship, I have to mention one application in connection with an appeal, my lord.
It's for
Lord, application for first one is for condemnation of delay, and second is for stay, my lord. I am facing an contempt before the first single bench. My lord.
give next week.
Great. Lordship, may I be permitted to mention this matter, Lordship? Last occasion when I mentioned this matter before your Lordships, it was fallen from your Lordships that whether writ petition against Mother Dairy is maintainable or not. Lordship, as per my understanding,
So we asked you whether it is a cooperative society or not.
Lordship, it is a private company, but it is wholly owned by NDDB, National Dairy Development Board, Lordship.
So why? What happened? What is the writ petition for?
Lordship, writ petition was preferred by the petitioner in 2022, Lordship. He was disciplinary, after a disciplinary proceeding, Lordship. He was terminated from his job, Lordship.
So what happened? What
And then in the writ petition, Lordship, order was passed, but by directing the general manager of Mother Dairy to pass a reasoned order, and the reasoned order was passed, but without considering my submission and without considering anything which I have replied.
So that order was pending in the writ petition.
Lordship,
The reasoned order.
reasoned order was not pending, Lordship. The reasoned order was already passed.
No, reasoned order was pending consideration before the writ court,
Lordship.
which has been decided.
Lordship.
Give. So what do you want? You want an appeal to be included? It is on the list.
It is not in the list, Lordship. I am praying for inclusion in the list.
Yes, give it. Inclusion monthly list.
My lord, may I mention one matter, my lord?
Yes.
My lord, I mentioned the matter on Monday, my lord, that Calcutta Police Constable recruitment, my lord. We had filed, we have served copy, but it was directed to be listed today, my lord, but it is not in the list, my lord. My learned junior had gone and handed over the slip since your lordships were not there yesterday. Would it be your lordship's pleasure to keep it tomorrow, my lord, at top, so that, my lord, it can be taken up?
But nobody is here. We don't know which case you are trying to.
My lord, my learned junior will be in the other court. She will go and hand over the slip once again if necessary, my lord. But your lordship's court officers know, my lord, because we had handed over the slip.
We have accepted, then why it is not listed?
WPCT 257, my lord. WPCT 257.
CT.
WPST, my lord. I'm sorry. WPST.
257.
My lord. My lord.
Of 25.
25, my lord.
So we have already allowed. Yes, it will come.
Lordship.
They are informing that the file perhaps came late yesterday.
Lordship. Lordship. May it be taken up tomorrow, my lord? I'll give a notice to the others.
Please, yes, you do that, and please ask your learned assisting counsel to come and
yes, my lord.
Verify.
Yes, yes, my lord. Yes, my lord. I'm grateful, my lord.
Item number 1, 2.
Item 1. Item 2, my lord, IAP for the petitioner, my lord. Same issue of doctor resignation has been.
Yes, the doctor resignation matter, my lord. Your lordship knows I am doing other 2 cases. My lord, I informed your lordship on the earlier occasion, my lord, that the recruitment process of new doctors is on. Well, if it can wait for some time, my lord, I think, my lord, this problem of the petitioners will be solved, and my lord, your lordship did not take the trouble of passing orders right now, subject to lordship's, my lord, consideration. I am saying,
my
lordship knows I know the fate of these matters, I know. But since the process is on for recruitment.
No, last day he had agreed because he was of the view that he will have to chase every step. So it is better that if it concludes. But how long you think it will take?
My lord, it is already on. And my lord, I am told, my lord, that by end of this month, my lord, at least the interview
I can
process.
wait, my lord. I'm not on that, my lord. But my learned senior friend, I have a high dignity for him, my lord. So I won't say anything. Only thing, my lord, your lordship kindly take, even after lordship's oral caution, still they're doing the same thing. This should be stopped for one seat or for all, my lord.
We are taking up that issue in one matter. We will see.
My lord, the 2 other matters, my lord, are there.
Lord,
in all this,
my lord, then, my lord,
it will not be taken up today.
Lord, other matters are there, my lord. That is hopeful, my lord. But I
matters are
I
not
may say,
likely
my
to
lord,
be
your
What
lord,
is the serial number? You are underestimating us.
no, I will never say so, my lord.
So
What is the serial?
that timing gives up some bidding time, my lord. If
All
you
right,
can,
let this come in the next month.
Next
In the
month,
meantime, if
lots-
nothing happens, we'll proceed. If you want to file something, they must not have filed any opposition or
No,
anything.
but what my learned senior friend just now said, my lord, I may say, my lord,
I
we have
can- I
agreed
can-
that there is nothing that stops. But so, my lord, in the affidavit in opposition, what they filed in the other petition,
It will be the
Same.
same.
issues will be the same, my lord, the same
Let
thing.
us see what happens in the meantime.
but I
We
have
are
not read
informed.
this very well.
We are informed. Affidavit of service taken
Designation
on.
of doctor's issue.
Either way you mention, if it is resolved, you mention
if
so
not,
that
I
it
shall
can
mention,
be
I'll
disposed
mention,
of.
I'll mention.
If not, then we will proceed.
So that all the matters can be disposed of. Lordship, I'm grateful.
Item number 3.
Item number 3 is, my lord, also my application. My lord, this is, it's not case of a doctor taking resignation. My lord, this is a case, my lord, of study leave. My lord, my lord,
Mr. Mukherjee, is there any list of your state law officers?
Yes.
Can you be kind enough to give us a copy of that?
by
Yes, yes, and as per your convenience. Yes.
No, my lord, this is a case, my lord, where the petitioner before lordship, my lord, approached the authorities for getting a study leave. My lord, it was rejected on the pretext, my lord, that 333 officers were given training reserve. My lord, after this order of rejection came into force, my lord, the 333 officers given training reserve facility, you cannot be given study leave. But thereafter, several orders were issued granting study leave to other officers. But even after my rejection, including a subject in which I also tried to go for a study leave. But initially, I approached your lordship, but lordship said, as because there is nothing urgency, go before the learned tribunal. My lord, the learned tribunal, after hearing me, my lord, has allowed my petition after rejecting the, my lord, the order of the authorities. I filed a contempt petition. Now, my lord, what they are doing, my lord, as because the tribunal is not functioning, my lord, neither they are taking any step for complying with the order, my lord, judicial orders remain uncomplied with. Now, my lord, I have no other means, my lord, as a tribunal is not functioning, I have to approach your lordship, my lord, so that at least they comply or they file in a, my lord, writ petition before this court. I don't mind for it. But they're doing nothing just as because the tribunal is not functioning, they're sitting idle.
Where is the order of the tribunal allowing your case?
Yes, my lord, I'm just coming, my lord. The order of the tribunal allowing me, my lord, is that page 128. No, what is the time?
So there is no challenge to this order by
No,
the state.
But this is an order dated 11th of August. No, no, it is no, no. What is it? No, it's not about that. No. It's December date. Can I tell you? No. Sorry.
Yes. It's a positive direction. What are you doing?
There is a on a page 100 and 104, when in a similar circumstances, December Court directed that if he gives an undertaking that he will claim for any salary, then he will be given study leave. Well, that is with regard to one matter, my lord, an interim order.
So the authority is sitting in appeal over the tribunal's order.
No, certainly not.
Either comply or face the consequence. What else? Right, wrong, indifferent, we cannot look into whether the order is right or wrong.
No, but that I can say until it is
Therefore, we are saying there is a positive direction
positive direction by the tribunal to arrive
within 7 days, and this order is of August. 4 months instead of 7 days, 4 months. Yes, who is responsible for this?
But the director of health services, Dr. Shopon Soren, well, his direction was upon him, my lord.
Neither the order has been challenged by him, nor he is complying it. Can it be done like this?
No. I should have to ascertain whether order has been challenged or not, or whether release
Are
order.
you aware?
No, as of now, my lord, my client will have not received any copy of writ petition assailing this order. No. I'm happy, my lord, had that been there, my lord, at least I don't have to come with a contempt, and my lord, I know it's very limited scope I do have. Had that been an appeal, my lord, I could have placed my case in further better way.
So we are asking, we don't know. He probably doesn't have instruction right now. And when did you file the contempt?
My lord, the contempt petition was filed, my lord. My lord, 28th of August. My lord, page 120 is affidavit position, my lord.
It is submission.
Item number 4.
Your Lordship, I am appearing for the petitioner. I am led by Mr. Subroto Mukhopadhyay. Due to some health issues, he is not coming to the court. Your Lordship, I am praying for 2 weeks adjournment.
2 weeks.
Yes, Lordship.
2014. Has come. He was dismissed for default.
The CAN application. It is a CAN. What is the CAN number? CAN 2. 570. What is CAN 2? This CAN can be considered.
Appeal appears to have been dismissed for default in 2017. Why is it listed today? We don't. CAN application.
Modification of the
CAN 2 of 2014. Application for the student. It's already dismissed for default in 2017.
Not required.
Item number 5.
Item number 5, my lord, Mr. Sushmita Shadatte appearing for the appellants, my lord. He is engaged, she is engaged by the Minister of Law and Justice, my lord, but till date, my lord, no copy of the, my lord,
2014.
I have no copy, my lord. She has also not been provided by the copy.
Call
my lord.
her, call her. We'll see. We'll read
But
the
you
file
kindly give
together.
us 1 week time, my lord. I will.
We will read the file together, sir. You made the same prayer in March 25.
Yes, my lord. Yes, my lord. But
Cannot
till
be.
date, my lord, we are.
February, March, every time same thing. You don't have the file. Government of India.
They have not provided us, my
We'll
lord.
record that none appears. We'll dismiss it in default. What is this? For the last 8-10 months, you are not able to get a file. It should keep it. We keep adjourning it. 2014-15 matters. This is you have to take some responsibility for these matters. Ask her to come or you help, you assist us. This can't be done on an everyday day in a routine way.
My lord, in
Not
that,
expected from a Government of India council.
my lord, in that case, my lord, kindly fix at 2 p.m., my lord.
Yes, ask her to come. We are reading the file.
She has not come to court yet, my lord. She will come, my lord. For that,
Then you start. The court can't wait for
my lord,
such delay by the lawyer in coming to the court.
my lord,
Sorry.
I'm seeking apology.
By section 5. Section 5 is pending.
Pending.
Can take it to 1.
You know anything. You're just standing here. You will not record your appearance. We will not record your appearance.
I am not
This
the
is the
appellant advocate, my lord, also, my lord.
You can't take such a position in court proceeding. You have to appear with some responsibility. come here walking casually and take an adjournment and go for 8 months in a 2014 matter. Government of India is not interested, then don't proceed.
But as a last chance, my lord.
What last chance? How many last chance?
That is this one. Okay. Yes.
Item number 6.
My lord, I am appearing on behalf of the appellant, my lord. There is a delay of, my lord, 118 days. My lord, earlier the coordinate bench has directed because, my lord, it has been recorded 92 days. And the learned coordinate bench has pointed out you filed the supplementary affidavit explaining the same, my lord. I am filing the supplementary affidavit. Well, the point here, well, we are challenging the order passed by the learned single judge on the ground. The learned
You are
single,
for the respondent.
Read petitioner respondent.
learned single judge has directed to reinstate the person who has already superannuated. My lord. Neither the petition,
Superannuated on the date of order.
yes, on the date of the, before the date of the order, my lord, neither the petitioner has pointed out the same, nor, my lord, the respondent has also not pointed out. My lord, kindly see the B form register. Your lordship knows that. So for the B form register is concerned, it is a statutory document, my lord. As per Mines Act, my lord, kindly see. His date of birth is 1954 because, my lord, at the time of joining,
Oh, where is the order? Show us the order of the
my
honorable.
lord, page, 68. Relevant page at copy of the inquiry of
Sorry.
Yes.
My lord, kindly I hand over, my lord, the B form register, my lord.
For?
It is a statutory documents as per Mines Act, your lordship know very well. My lord, kindly say the date of first appointment is 15th May 1974.
Yes.
My lord, at the time of joining, he's declared his date of birth, age as 20 years
Yes.
in 1974. That
Yes.
means he was born sometime in, my lord, 1954. My lord, if there is no specific date has been declared, then it is treated as his his date of retirement must be 30th June 2014. Whereas the, my lord, learned single judge has passed the order on 24th December 2014. Near about after six months. Petitioner has not pointed out.
Why you have not pointed out? It's not in your absence.
No. My counsel also, my lord, I've seen that.
So why you are saying petitioner has not pointed
It
out?
is contributory negligence on the both sides, my lord.
No, it is fully your negligence. You are employer having his full service records and you don't point out to the court and then you raise the same grievance in an appeal. How can you do this? If at all you are required to point it out to the honorable single judge. And if there is an error of record, whether it is to be raised in an appeal.
And my
It
lord,
is essentially an error of record, a vital fact which was in existence you could not produce before the court.
and my lord, at the time of my lord scrutiny, it was found out that
So apart from reinstatement, there are other directions.
yes, my lord, de novo inquiry. There is de novo
There
inquiry.
is no provision for continuing the inquiry post-retirement
No,
in railway.
no. It is Eastern Coalfields Limited.
Eastern Coalfields, there is no such provision.
No. So far, my
Anyway, no, don't say so far my instruction. We want to see from the rule whether there is any provision.
my lord, will bring then certified standing orders, my lord. I'll produce the same.
Just find out if there is some, then why? Now he must have retired anyway.
Yes.
So you took no action pursuant to the Honorable Single Judge's order.
No. My lord.
And since
Till it-
2014, no
Yes, matter
nothing.
heard by the earlier bench. Earlier coordination has directed them to file, my lord, affidavit.
Not hard. It was only the direction that if you want, you can file. Not hard.
Without hearing, court has given direction for
Right.
affidavit. You are not there. Your junior was there.
Anyway, I was being instructed that.
So you have filed your opposition.
No, I have
No.
not filed. I have asked the, actually, person is now residing at Bihar and he is so ill.
Then
bedridden.
don't
I cannot file the opposition. I am ready with
Don't
the
file.
opposition, but I cannot file.
Then don't file it. It is your choice. There is no mandate. You don't want to
And
file, you can
he is
proceed as
already bedridden and he cannot come also. No, anyway, I will not.
you have to either file or not file.
I will.
We are not concerned.
If I can, I will. Otherwise, I cannot file. I will not.
You just go through the statute.
Yes.
Tell us. We'll take it up on Monday or Tuesday. We'll not wait any further.
Tuesday.
Yes, as prayed list, as jointly prayed.
Item number 7.
For the respondent. You are for respondent or petitioner? Appellant.
And two.
Matter is a ready matter, my lord. Your lordship can't pick up the next Thursday, I shall be later. The Gopal goes is appearing. Although his junior has not come, junior, he is my lord. Yes, he is my
Not to.
Item number 8.
What file?
There is a
আঠেরো বারো 18
the date list on Thursday.
Item number 9.
Seven.
None appears on behalf of the.
Item number 10.
These matters are same. I think up to 18. Call the next, same order. Perhaps up to 18, it is all the same. Let us see. Same order. Winner.
Item number 11.
In patch of cases. Same order. Same order. No. It is kept pending. That is
13.
they have participated. For entry. Put it together. And then we go to skip. Plus deposited longer. Now the matter is planning of the part of maybe this goes because order. You can go to telephone. No order. Some recruitment profit of 2007. Same.
Item 13.
Must be the same. Same. Yes.
Item 14. Fifteen.
Okay. Up to 18, I think.
Item 16,
They have to post it. They have to post it. Same.
item 17,
17, I am for the petitioner, my lord. Your lordship, I have some instruction from my client whether he is interested or not. My lord, kindly grant me 7 days time, my lord. 7 days.
For obtaining instructions from the Are you aware they participated in the interview or not?
Yes, my lord, I have no instruction, my lord. So my lord, I pay for time, my lord, to
Interview was just one day after the order.
order থেকে same
That
order
if they are able to, they will participate. So probably nothing survives. Most probably. Find out.
কবে আসবে?
Same.
18. Item 18,
শুরু হয়েছে 18-12 8 থেকে 18 8 থেকে সেম অর্ডার চলছে 8 থেকে সেম না সব 18-12 চলছে সেম অর্ডার ফুল ডেট টান আইডেন্টিক্যাল ম্যাটার কোথায় 9 থেকে
nineteen,
Matters are being listed. Disposed of matters. Again. Huh?
Delisting. Or delisting. Dead record. Record is dead.
It's already dismissed. What order is to be recorded? It is dismissed in default. Why they are being listed if it's already disposed of?
Item 20, hmm. Right, করে দিন।
None appears on behalf of the
Same.
21, 5.
none appears.
Item 22,
Vice.
None appears. Same order, first day.
Twenty-three.
Item number 22, my lord. Item number 22, my lord, I am asking for the respondent number 2, my lord.
Yes. Respondent number 2 appears virtually. Make a note, respondent number 2 appears virtually.
Grateful, your lords.
Yes, 282 is allowed. 50 is dismissed. Also dispose of matter.
Twenty-four.
I'm for the petitioner. I am appearing on behalf of Sudip Palchoti. Due to some personal problem, I am praying for 1 week time, my lord.
All right, MS so and so appears. For whatever it is, she is on prayer made by
Deeply obliged.
25, 26, 26.
None appears. Same. Ah.
Ah. 27,
Same order.
Item number 29.
29 for the petition. The matter, my lord, where we have challenged the order, the crux of the matter is, my lord, whether the promotional post can be filled up by way of transfer by a person holding a feeder post and without following the reservation policy. On the earlier occasion, my lord, we have submitted a short list of dates and submitted. ठीक है. Stop there.
It was assigned to a particular bench.
But that bench is not taking up the matter.
No, but that is a different thing. But there is an order of the Honorable Chief Justice assigning it to a particular bench.
That was after that. But actually, we were not aware of whether it has been assigned because it was released by Justice Devanshu Ghoshak.
Then you were not appearing.
Yeah, we were appearing, but when it was assigned, Miller, we were not made aware of the same because we didn't ask for any. We merely made inform the court that since the matter has been released, it has to be assigned to some other bench or the bench which are taking up the matter on usual course. Thereafter, the matter could not be was not taken up.
No, after assignment, it has been taken up by the assigned bench on 3-4 dates. How are you saying all this?
That bench was continuing, but thereafter, Miller, that bench did not conclude the matter.
Which bench?
Last bench, Miller. No. Justice N.M. Velumani and
Correct. So it was assigned to her. How you are saying you don't know? After assignment, she has been hearing.
Sir, after this bench, Miller, this bench did not conclude the matter. So there was no bench. Thereafter, it was taken up by Justice Surya Prakash Sherwani and Rajarshi Bhardwaj, which directed to be placed before the appropriate
There
bench.
is an order of assignment.
Not there.
Just now you said you don't know. Now you are saying everything.
No, my lord, that bench which had taken up the matter on the assignment, that bench is not there.
You think we don't know? We have seen that.
My lord, thereafter, the regular bench has to
We
take
don't
up the
know.
matter.
We don't know. It is for the chief to decide whether he will assign again or it will be taken up for us by us. As of now, there is an assignment. We'll see. Let the honorable chief decide, then we'll consider. Honorable Chief Justice.
Item number 33.
Yes. None appears. Same order. First day.
Yeah. 33 क्या नहीं लो 34.
Directing for examination of affidavit. This is affidavit on the part of petitioner. Affidavit reply. Order is good.
Lord, in this case, my lord, I am challenging the order. So,
Yes, give us a minute. Please.
Packet koriye chana, Raji. Huh? Koriye sir. Order. Hearing matters of weakness.
Yes.
My lord, factual aspect of the case is very much peculiar. Interview, recoupment is. Now, my lord, call letter was written. Very, it has been published by the respondent. I mean, call letter has been joining letter submitted subsequently. Executing a service of on the part of petitioner without any disturbance. Without any disturbance. Now, my lord, surprisingly, while the petitioner paying for fixation of monthly salary, I am terminated from the post of my service.
Where is your application for monthly salary?
Well, this is, my lord, kindly come to page 56, page 59. Sorry, that is page 49 to 55. Analogous.
49.
49 to 55. All of applications are directed combined. 49. Listen, 55. But page 55 is very much important.
page 55.
Yes.
Matter, madam. Allegation is whether the forged document has been used in respect of the getting service from this appointment from this department. Well, Lord, my little understanding is very much clear. Not a single complaint has been lodged against me, either respondent. No such facts and findings sought out by the respondent. On the basis of information, they are terminated from my lord. Now, my lord, when we come to the page 57 of this is the discontinuation letter. 6 and 57, both. Well, on 56, I am just to read out. Sent here with a petition dated such and such, received from the Subendu Adhikari, Subendu Bera of Purbo Medinipur, along with its enclosure forwarded by the office of the Chief Secretary under such and such memo dated such and such on the subject cited. You are thereby requested kindly to take immediate requisite actions after the receipt of this letter and kindly send the action taken report and intimation to the department. Just intimation, not hearing. Now, my lord, kindly come to the page 57 of the petition. Read out. As the appointment was against the rule, Sri Subendu Bera. As the appointment was against the rule, Sri Subendu Bera, working as a computer operator in your office, may be discontinued for two. This is my order for termination.
Yes.
Without hearing, my lord. There is nothing for police report other verification. Nothing.
Before engagement, police verification is not
Not
required.
necessary. As per my little understanding.
Mandatory. Verification and what are the
Not necessary.
Before engagement,
No,
as data entry operator.
no, but
this
before
casual
any
post.
video for any appointment.
No, we are asking, we are not, we didn't say appointment. We said before engagement or as data entry operator is a medical and police verification required.
And if you page 7 for a reading opposition, there is no record. Paragraph 20, Roman 3. There is no record of any recruitment or engagement having been made by the division of structure as computer operator, data entry operator. There was no such post of above description director of forest at the material point of structure. And this all the before engagement for appointment any post, there must be a police selection post. There must be an appointment letter. There must be a police verification. Before appointment letter, there must be a police verification. Police verification report and medical.
So,
The police verification report and the medical examination. Chapter 4.
to file a department.
After appointment, he will show a police verification report.
No, before appointment, police verification is necessary.
So that is why now at any point in a person's service career, you can ask them to produce the police verification report and medical.
That's what the tribunal finding is that this all are false documents.
This is their allegation.
Please, sir, we have heard you. Please wait. Yes.
Kindly see,
Who has issued P3?
page 56.
Who has issued P3? Page 36.
According to this document is not available in our office. That is only a academic. Page 7, paragraph 21.
Then how he was paid any money?
The report was paid from the contingency fund.
By whom? That is what we are asking you.
Shubhendu Bera, son of Sushil Kumar Bera, appears to be work on a temporary basis as a divisional forest office for Jason Jadwal Dated Deva during March 2010 to 2012. Cash book limit based on works in Bera was paid for different amounts in different months by attached forest ranger, monthly disbursement, such as which different months. The wages are disbursed from the appropriate head of accounts. Equipment or engagement made by the technical constructor as computer operator, data entry operator. There was no post above description in the director of forest customer at a material point. There is no evidence or record relating to issuance of the permanent appointment data at the court that is reading of the permanent data. Stipend area, but that is not.
Huh?
But I see stipend and see the page 36.
Yes.
You will be per month, yes, amount is 4,000 as stipend. That is most of language used to get.
So how was he paid? That is what we are asking you. He has continued for nearly 2 years.
But if something has been wrongly done.
Wrongly done by whom? Who paid him? That is why we are asking you.
But a cash book was paid for a different amount, different mark for the attached forest register.
See, he cannot put his hand in your treasury and take the money.
No, not treasury, not from the treasury. In the cash book in the local office.
So, therefore, if he has been taking it every month, you have been giving it for 2 years, then it is not that.
After subsequently it is found that all are paid documents.
So, who is the officer responsible? That we are asking you.
Either division for structure.
What happened? What did you do against him? He has created this kind of a situation. All right, we have understood what you are saying about him. Whether it is forced or not, that is a different thing. For that, no proceeding was carried out. No criminal case was lodged. Merely because it is in your head that all this is forced, therefore he has been disengaged. Sir, you can say that for any government employee tomorrow. That all your documents are forged, you go home. Is it possible?
Sorry, 57. 57 for a moment. 17,
And that's not the reason assigned in your order disengaging him.
What he has a computer in office, the appointment was against the rule.
All these findings the tribunal has recorded, we don't know from where. The order is only to the extent that it is not an appointment in accordance with rule. We disengage.
This type of appointment letter never issued by the government.
So therefore, again, somebody will have to take responsibility.
If the inquiry has to conduct a person concerned, certainly.
Why not?
That will be conducted.
Yes. What is his right is, but these facts are not there in your order. The disengagement order, come to the disengagement order. It's a one-line order.
Yes. Because
discontinued forthwith. That is all.
If somebody engaged illegally or obtained
details from the appointment letter we made. I don't. That's committed to edit.
We are only on the tribunal's findings. We are not on your order. Your order is very clear. It says disengaged. How the tribunal has recorded a finding that is forced, fabricated, how it can be done without any opportunity to him? Cannot be. If he had come to your office that day itself, you had returned it that no, these documents are not issued by the office, you go home. Then if he would have gone to any forum, it would have been a different matter. Based on those documents, which are apparently perverse, they don't mean anything. From where he has got these findings?
We have considered the entire aspect.
What entire aspect? You file a report and the tribunal says he is forced. Wonderful.
No, but the reply was filed before the trial.
What reply?
The reply.
That reply and rejoinder will not substitute a proceeding. If this is accepted, then just imagine tomorrow you can wake up one day and say, give anyone a letter that everything you is forced and fabricated. Go and get your matriculation certificate. Now go home. How can you do this?
No, but under the rules, Lordship know better than me. Before any appointment letter is issued or the appointment is made after selection, there must be a police verification report and medical exemption. But transport staff.
And at which stage this is to be examined? Under the rule? After 2 years of service?
No, but after appointment, but when he asks for a salary, when he asks for a salary.
He has been paid for 2 years.
No, but kindly she paid for salary, not on the particular post.
Yes, correct. So therefore, that is why we are saying from where all these findings have come regarding a forgery. He has been engaged as a computer assistant data entry operator. He has been disengaged. It is simple.
Simple.
Why the tribunal has recorded these findings that it will cast a stigma on him. If there is such a finding is standing, then it will cast a stigma on him. He was engaged, he was disengaged within 2 years. That is a different way of looking at it, because
not against a permanent post. Or
there is a question of permanent post. It says to concern to perform the duties in the office, computer assistant and data entry operator. It does not say permanent post. Nowhere there is mention of any sanctioned post. Nothing. He has been engaged.
You will be per month some of 4,000 as per your stipendary allowance.
So therefore,
this type of appointment is never issued.
Therefore, we are saying there is no occasion for the tribunal to record all this finding regarding forgery. If there is a forgery, then who is the responsible officer who has paid him for 2 years? All these issues will arise.
Certainly, one thing that certainly it is an obligation of the state to conduct an inquiry,
Then,
vigilance inquiry.
So that tribunal's finding is, we don't know from where it has come. The order is clear, page 57. Working as computer data entry operator in your office may be discontinued. There's no question of any permanency. There's no rule sustaining the engagement. So they have said you discontinue. You discontinue. Now going into forgery, where is your police verification?
Whether this disengagement is proper or not.
That is the only thing, that the tribunal's finding is casting a stigma on him, that he has forged all these letters and he has gone and joined.
But till date we have not against launching a FIR. Because
and still he is become a guilty person.
No.
Yes, this tribunal's order makes him a guilty person. He is guilty of committing forgery and obtaining an appointment.
Unless,
just see what the tribunal says.
Seems to be manufactured.
What more?
Not finding.
Yes.
Seems to be manufactured.
Yes. That's all. Anything else you want to submit? Yes, heard. learned advocate for the writ
Item number 35.
For 1 week accommodation, my lord.
The old matters, please don't embarrass us by asking for.
Only 1 day accommodation, my lord, kindly, my lord.
What is it? Let us see. It was taken up recently also
We are in the direction to file a report by the state authority.
by the
State authority. Direction. The earlier direction by the honorable.
What is the issue? Some pay enhancement.
Pay enhancement.
You are claiming benefit of revision.
Yeah, the brief is not with me, my lord.
What is it, sir? You know? Pay revision. Fifth pay. Yes. So what is the dispute? So you were required to take a decision with reference to the fifth pay commission. For what happened? You took no decision. He's an employee. Directorate of Health Service. Have you seen the last order? No, 18-9. 18-9 order. Yes, what is the order? Just have a look. The director placed it before the finance department and thereafter consequential direction was required. Perhaps it may have been finalized by now or rejected, we don't. So what happened? That is now you have to report on this. Now it is not at the direct. No, now it is not in the hands of the director. Finance department. Yes.
Much obliged.
Item number 37.
My lord,
Yes.
there are three matters together.
Can you tell us briefly before we'll open the file, what is the issue?
My lord, there are three matters together. In one of the matters, there are a number of applications. It is in 38. Your lordship is fine, my lord. These
Yes.
applications are substitution with clear limitation, condonation of delay.
So many applications.
Well, these are substitution of all the widows of the original applicants. And the widows they live in the far distant place of Nadia district, very interior place. So that is why a limitation and application for condonation of delay has been made. Substitution in place. I do not know what Mr. Mukherjee is going to say.
In a writ proceeding, what delay?
Widows.
No, therefore we are saying it is a writ proceeding. It's not a civil proceeding. Yes.
Let the application for substitution along with the condonation, your lordship, after all, it is a question of the court of equity also.
No, before
But
that,
let the application be disposed of.
just want to know what the issue is.
Yes.
If you can just tell us without going into the file, what is the issue?
Well, the issue is, it was all relating to the qualification and appointment in the post vis-a-vis their pay. It's a long dispute. But the matter has went up to the Supreme Court. From the Supreme Court, returned back. And then, in the High Court, from the High Court, it is to the tribunal. So all the three matters, my lord, is 37, 38, and 39, the original matters, it will take some time to argue. But so far as the applications, my lord, I have made this, because it is all the poor widows.
So many applications.
So many, yes. It is in one particular. In
Every substitution is accompanied with an application for condonation of delay.
Yes, yes.
Where is the question of abatement? The writ proceeding, why abatement?
Well, otherwise they will not be entitled to get the.
No. What we are saying is,
Yes.
why to get into this procedural wrangling of condonation and abatement? In a writ petition,
It's all right.
the substitution can be.
Well, it's substitution, but individual application for condonation has been made. So it is unto your lordship to decide.
No, our difficulty after looking at the number of cans is how to segregate which is which.
Every can is related to the substitution and the condonation of that.
We will request your learned assisting counsel to do some work. Give us a list of all the substitutions, all the condonation and all the abatements separately.
I personally have made it.
Huh?
I know where your lordship will put this question. I personally have made it.
So
I can say it, my lord.
can you give us a copy?
I can.
So that we'll have to pass an order, therefore we are saying. So just give us a copy on the next date.
Yes, my lord. So your lordship will pass the order later on. Allowing the and fixing the matter, original matters for.
Please see what we are expecting is the petitioner's name, the substitution, and in respect of that substitution, the condonation and abatement, name wise.
Can number.
Yes, can number. Petitioner and 3 cans related to that petitioner.
In
Petitioner.
course of the day, my lord.
Huh?
It will be given. Today itself.
So please give it. Today we are not recording it. In presence of learned state counsel, the matter is adjourned for the day.
Third. Item number 40.
Yes. Nobody is appearing. Call again. No, call again. 40, call again.
Item number 40.
Give the file.
Twenty-one.
You have filed the opposition. There was a direction for filing opposition on September 24th, September 24. None appears.
I'm praying for inclusion for hearing of Group 6 matter.
Original side.
Original say, please.
Next one, please.
Next one.
My lord, may I permitted to mention two Group 6 matter for inclusion, your lordship.
Original side matter, item number 1.
I'm for the applicant praying for not today as I'm led by Mr. Shoham Dattu. He is briefed in this matter. He won't be able to conduct this matter today. So as he's busy in attending one death ceremony of his close relatives. Item number 1 and 2.
But in 1 and 2,
I for the respondents.
in both cases.
Yes. Well, the next week I have personal difficulty.
In the
Can you be listed on next year?
4th week of
Then an advocate. Yes, 1 and 2, both.
Item number 3 and 4.
My lord, item number 3, I am the appellant, and in item number 4, my lord, the writ petitioner is the appellant, my lord. It is the same order, my lord.
Yes,
At number 4, my lord, there is a delay of, my lord, 29 days, my lord.
only.
My lord.
You address.
Yes. I have very limited point, my lord, in this matter, my lord, because the point involved in this matter has been, my lord, in similar cases, my lord. There are so many cases in this matter, my lord, which were my lord, decided by the Honorable Division Bench, my lord, and the matter went up to the Supreme Court also, my lord. But here, my lord, only thing is this: if your lordship takes up, my lord, the judgment, my lord, which is at page 93. Facts are jam in, my lord, to some extent here, my lord. This is the judgment which is under challenge.
The condemnation application is in which matter?
The
My
first
lord,
matter.
first matter, my lord, condemnation application has already been allowed, my lord. In the second matter, my lord, there is a condemnation application.
How many days?
My lord, 29 days. my lord.
29 days. Same order in the second matter. CAN number? Sorry, what is it called? GA number?
GA number, my lord.
1.
G1, my lord.
In GA,
Only in the next
same
matter.
order in the
3
court.
or 4, my lord.
Yes. Yes.
Can be taken up together, my lord.
Yes, yes.
Same matter, my lord. This is the order, my lord. Here, my lord, what happened?
Just instead of 26, it will be 29 days. Yes.
Before I address your lordship, my lord, before I begin, my lord.
No, you said the issue is settled already.
Settled, my lord, to some extent, my lord. It is settled.
To some extent, yes.
To some extent, my lord. Here I urge only 1 point, 1 or 2 points, my lord.
What is
But
the issue that has
is
been
here,
settled?
my lord. It's in the Eastern Coalfields Limited, the coal company, which is a subsidiary of Coal India Limited, my lord. May I first hand up this document, my lord?
Just give us the background. We'll see everything. Yes.
Yeah, my lord.
Tell us what is the issue which is arising for consideration.
Is the my lord, disbursement of the or direction for payment of MMCC, which is called monthly monetary cash compensation, which is paid to a female dependent of a deceased worker in lieu of employment. Female dependent of a deceased worker in deceased worker in lieu of compassionate employment.
Instead of family pension, this is something.
Yes, this is the scheme, my lord, but this is not an unilateral scheme. This is a scheme, this is a bipartite settlement between the trade unions, different trade unions, and the coal companies. So they come into a settlement. So this is basically an agreement, and this is also a settlement as declared by the Honorable Supreme Court. Now, my lord.
So applicability of the scheme is not an issue.
No. Not at all, because both the parties, my lord, whether the worker or the employer, they have to abide by this scheme. They cannot.
So is it your case that for some reason they are not to be paid?
No, what is the date for which? Because here, my lord, from the date of death, it has been granted.
Oh.
My lord, whether it's in this case, in this particular case, whether it is from the date of death or whether it's from the application or from the date of the application making MMCC. There are judgments, my lord, which say that the right accrues immediately. My lord, it is, my lord, the right accrues immediately upon death of the worker, my lord, whether for employment or for MMCC, that is monthly monetary cash compensation. Now, here, my lord, what happened, my lord? Here, my lord, this writ petitioner's husband's name was Shadan Dhangar, who died on 6th February 2017.
5th February.
6th February 2017.
Yes.
Now, the death information was provided by the writ petitioner on 22nd of February 2017, which is at page 49.
What was provided?
Death information. This is the death information. But without submitting any death registration certificate, as will appear from that letter, which is at page 49. Now, my lord, 2 years thereafter, my lord, what happened? The deceased worker's elder son, Ram Dhangar, he made an application for employment, which on 5th of February 2019.
Yes.
5th of February 2019, which is at page 50. So, my lord, the coal company ECL, it issued a letter dated 13th of May 2019, which was followed by a reminder letter dated 5th of October 2019, asking Ram Dhangar for rectifying certain shortcomings, which is at page 57. Now, 2 years thereafter, my lord, everything is silent. There was nothing from their end. Now, 2 years thereafter, the writ petitioner herein, she issued a letter on 9th of December 2021, which is at page 58, giving the information that Ram Dhangar, that is her elder son, who made the application for employment, died on 27th of September 2021.
And what is the date on which she gave the application?
She, my lord, her son or she, my lord?
Oh, when did she intimate you regarding his demise?
Demise, my lord, first is 22nd of February 2017. The intimation as to
22nd February, intimation was sent regarding deceased employee.
Yes.
Then you said that elder son applied in February 19.
Yes.
The company was requiring some intimation or information in 2019
itself.
Then the son passed away. What is the date on which he passed away?
Date, my lord, Ram Dhangar, my lord, he passed away on 27th of September 2021.
And when was this intimation given to you?
9th of December 2021.
All right.
With that intimation, my lord, it was requested, it was applied that the employment be given to her younger son.
Yes.
Whose name is Sham Dhangar. And
Yes.
Sham Dhangar himself also made an application for employment.
Yes.
On 11th of May 2023, which is at page 59.
May 2020?
On 11th of May 2023, 2 years thereafter.
23?
23.
Yes.
Now, immediately thereafter, we issued a letter, my lord, asking Sham Dhangar to appear before the medical board for his initial medical examination. It is the process, my lord. It's one of the part of the process, my lord, is followed for processing the employment claim or the MMCC claim for MMCC. So he was asked to appear before the IME for the board, before IME on 1st of September 2023. He didn't turn up. Now, about a year thereafter, the writ petitioner issued a letter on 23rd of August 2024 asking for MMCC. Now you pay me MMCC. No employment, you pay me MMCC.
So MMCC is in lieu of appointment?
Appointment only in case of female dependents.
Female?
Only in case of female dependents.
So if he was not entitled, why were you calling him for verification or any kind of scrutiny?
No. First, my lord, may I just tell your lordship what is the scheme? The scheme is this: one employment is to be provided it is there, my lord. One, employment is to be provided against death of a worker. Now, it gives the modalities or it gives the process how the employment is to be, who are the dependents and who have the rights. So, my lord, as per the scheme, all the dependents, now amongst the dependents, my lord, the sons and the wife, they are included. So, the sons and the wife all have equal rights as dependents, whether for claiming employment in case of male and in case of female dependent, whether employment or MMCC, because female dependent only is entitled to ask for employment if she is up to the age of 45 years or MMCC. If she is above 45 years, she is MMCC, she can ask for MMCC. She can ask for MMCC even she is less than 45. But for employment, it is the cutoff age is 45 years. Here, my lord, what happened? The female dependent is the wife. She didn't ask for her own employment. She said, give the employment to my elder son. So by this, it means she had consented or given her no objection for processing the employment of her elder son. We processed it. He didn't respond. He died. 2 years thereafter, intimation was given to us. Then a request was made by her younger son 2 years thereafter to give him the employment. We again processed it because under the NCW, this is the scheme National Coal Wage Agreement, under the NCWA, he is entitled. So we processed. We asked him, you come for the IME, he did not turn up. Now, a year thereafter, my lord, an application comes from the writ petitioner who is the wife of the deceased worker, you pay me the MMCC. We say, very good. You give us certain documents. ECL processed the claim and ECL issued a letter on 7th of October 2024, which is at page 72, asking for the necessary. You submit the necessary documents. We said that you submit the necessary documents which we require so that we can process. Now what happened, my lord? Writ petitioner submitted certain documents while her letter dated 15th of November 2024. But before we could settle the claim, writ petitioner filed the writ petition. The writ petition, my lord, where, my lord, an order was passed on 21st of January 2025, directing the director personnel of ECL to decide the claim of the writ petitioner. Pursuant to that order, my lord, we passed a reasoned order on 17th of February 2025, which is at page 86. And we say that you are entitled to MMCC from the date when you made the application. Now, my lord, in this judgment, which is under challenge before your lordship, here, my lord, it is said that based on a previous judgment given by the Honorable Single Judge, that MMCC is to be paid from the date of death without any interest, date of death. Why no interest has been provided? That the reason has also been incorporated in the judgment itself, that there was no lacuna or latches on the part of ECL. So far, this case is concerned. In other cases, my lord, if there are lacunas, my lord, interest were paid. Division bench also allowed the interest, but lacunas were there. Here, my lord, the Honorable Single Judge found that there was no lacuna on the part of the ECL. So ECL need not pay the interest, but pay the MMCC from the date of death. Here, my lord, what I submit before your lordship today, in the facts and circumstances of this case, my lord, whether MMCC is to be paid from the date of death or from the date of application. My lord, the scheme does not provide for any application to be made within a particular time. But there are judgments which says it should be within a reasonable time. I am not going into it. Here, my lord, my contention is this. Once the writ petitioner consented or given her no objection for processing employment of her son she had relinquished her claim or she had relinquished her right. Now, that right cannot be revived automatically. This is the point on which I have filed this application, this appeal, my lord. Whether it can be done or not. This point was raised in a previous appeal, my lord, but not adjudicated. Point was raised, but it was not adjudicated. Whether after consenting, my lord, obviously all the dependents have equal rights. So when one of them is nominated, whether for employment or for MMCC, so other dependents are to give their consent. So the moment they give their consent, they relinquish their right under the NCWA. Now, once they relinquish, whether it can be revived or not. But in the facts and circumstances of the present case, my lord, the rescind order was passed granting her MMCC. So I say, my lord, revival can be made only with consent of both the employer and the employee and not otherwise. Now here the revival was made effective as per the rescind order, my lord, from the date of making the application and not otherwise. I will cite certain judgments, my lord.
Where is judgment of this Maya Bauri?
My lord, I'm submitting.
Yes.
Now, I think, my lord, your lordship has gone through the relevant provisions of the NCW as it is there, my lord.
No, we have not seen that yet.
Now, but it's also in this judgment, my lord, it's quoted, but if your lordship is kind enough to have a take the copy of this NCW National Coal Wage Agreement, the relevant extracts from that, my lord. Here, my lord.
According to you, she should get it from which date?
Yes, my lord.
According to you, she is to get it from which
In the
date?
facts of circumstances of this case, my lord,
Yes,
they must
this case
submit
we are asking.
from the date of the application she made. According to me. According to me, from the date of, because, my lord, it is not an universal rule. My lord, right accrues from the, on the death of the worker, undoubtedly.
Even if there is a delay in applying, she can be deprived of the.
No, I am not depriving. I am not saying, but rather I have asked her to submit the documents so that we can pay her. And by the reasoned order.
If you have patience to hear us,
Very
then
good.
only you can respond.
Sorry.
If you start speaking before we complete a sentence, you will never be able to respond to any query.
Sorry,
What we said is, if you Can you deprive her of her dues from the date of death because she has applied belatedly? That is the only issue. You are saying from the date of application we'll give, but prior thereto we will deprive her or will not give her because she is not entitled. That was a delay on her part. This is the crux of your submission.
My lord, to some extent, my lord.
What is the other extent? Tell us.
I say, my lord.
Yes.
Once a dependent nominates another dependent, she or he relinquishes his or her right to claim employment.
You can't say that because you have acknowledged her right and you have paid
My
it.
lord, my lord,
You have paid it. How can you say this?
No, my lord, what I'm saying, my lord.
Yes.
By that reasoned order here, I say, my lord.
Yes.
First point is this, and that can be revived because as it is a bipartite settlement.
So ultimately it is an issue of delay.
That can be revived.
When she wants, she can take it. Prior to that, will not give.
If that had been the case, my lord, though in most of the cases, it's from the date of
how it is different from this case? Tell us.
There are certain cases.
How it is different from this case? In this case, the female applied for her son-in-law, and that is how the time lapsed. In this case, she applied for her son, and that is how the time lapsed.
That point which I am raising, my lord, probably it's not raised there, my lord. Because, my lord, if that had been the universal rule, my lord, there are though few, not many, 2 or 3 cases where the court was pleased to grant it from the date of application. May I place that judgment? 2 orders. Very few, but may I?
Those judgments were not placed before the Honorable Single Judge.
Not at all. That दुख नहीं हो जाता. But these are the copies, my lord. I have the division. This is a Supreme Court, Honorable Supreme Court judgment, my lord. Order. I have the Honorable Division Bench judgment also against which this SLP was preferred.
So what is the law decided in this case? Tell us.
What I intended to submit before your lordship by this, if it had been the universal rule that yes, you have to, whenever the application is made, you have to make it from the date of death, then this judgment would not have been passed.
We are asking you a simple query. How do you propose to distinguish her from this Maya Bauri?
Now, my lord.
You have not assailed the judgment in Maya Bauri? You have not assailed the judgment of the single judge in Maya Bauri?
It was Maya Bauri, it was.
No, you said that one of you said that it was not assailed.
No, my lord, it was assailed. So far I know, my lord, it was Maya Bauri. No, it was assailed, my lord, and it was not allowed. So it was not assailed. I must be very candid before your lordship.
Therefore, we only have to see whether you can distinguish. How can you distinguish?
Let me, my lord.
There was a delay of more than 20 years. How that will apply here? We don't know whether she had made any application for a son or son-in-law. There's nothing of that kind. How can we? How that case can be made applicable here?
Here, my lord, only the point of difference.
The only distinction is in Maya Bauri, she applied for son-in-law. Here, she applied for son. Otherwise, what is the distinction? Tell us.
My lord, whether, my lord, this point was with what I intended to raise before your lordship, my lord. Whether this point was there or not, my lord. Here, my lord, in Maya Bauri, my lord, It was given based on Putul Robidas and all this.
No, there also when she applied for son-in-law, she had relinquished.
Yes. Yes.
And
we
later
have-
she made an application.
Yes.
So what is the
But
difference?
that point was not there, my lord. But that
So
point
what
was
is,
not raised.
you urge that point, so sustain that point.
Yes, my lord.
Yes,
What
sustain
I
it.
say, my lord, once,
Yes.
because all the dependents, my lord, as per the NCWA, if your lordship takes up that NCWA, the definition of the dependents, who are the dependents?
There is no distinction about this. These are not facts in dispute.
My lord, why I'm saying, my lord, I understand, my lord, your lordship's query. My lord, why I'm saying that all the dependents have equal rights. So one of the dependents is to get a job. So the other dependents,
Therefore, you may try to emphasize with these nuances, the fact remains the same, that on facts there is no distinction between Maya Bauri and this case.
yes, ma'am. Yes.
You are trying to put it in a different way, which you say was not canvassed. So how do you propose to sustain a submission that there is any relinquishment when you yourself has recognized that there is no relinquishment?
My lord, I have what I have recognized, what I am saying, my lord, here, there is a relinquishment and it can be revived only with the consensus of both the
All as per your requirement or as per your
No, my lord,
perception, or there is some provision
No,
here.
That cannot be, my lord, not as per my whim.
So therefore, let us see whether this contemplates relinquishment. When an application is made for someone, it will amount to relinquishment.
My lord,
And where is the relinquishment?
the moment I give the no objection. Because if I do not relinquish the right, there are so many cases, my lord, where the matters were filed by the other dependents, not give, or they have obtained injunction. There are so many.
But a hypothetical situation that has nothing to do with this case.
No, my lord, what I
Those issues don't, here they are all in unison. She says that give my elder son, you don't do anything for 2 years. He passes away. Then she says,
No, no,
give
lord,
my
it's
younger
not
son.
It's not like that.
Yes.
Fact is something different. No, my lord, kindly see the judgment itself also,
Yes.
and the sequence of facts.
Yes.
We wrote to them. You come, give this document.
When did you tell her to come?
My lord, kindly see. When, my lord?
2 years, 3 months after she applied.
My lord, 2 years.
2 years, 3 months after she applied.
No, my lord.
Yes, sir.
No, my lord, initial screening both at the Kuriliv and Nilliv were done on 2/4/2025 and 2026. Page 18.
You asked the elder son to come for the first time in May 2019.
May 2000?
Yes, 13th May 2019.
Yes.
Then you asked him again to come on 5/10/2019. He has passed away. Now, will a passing away amount to a relinquishment? We have some
No, my
difficult.
lord, passing away. My point is not that.
Now she gives an application for the second son.
So we immediately moved it.
She made an application for the second son in 21.
Yes, we immediately moved it, my lord.
Yes. When?
Then thereafter, my lord,
When
Shyamdhagar
did you immediately move it?
Shyamdhagar made the second son made the application in 2023.
Correct. Correct.
So based on that application, because he is the claimant, he made the application in 2023. Immediately thereafter.
No. The mother told you about him in 21 itself.
It's not a case of a minor that the mother will do it.
So
my
did
lord.
you tell her that we cannot process
that,
it?
my lord, my lord,
That we cannot process it unless he applies.
There is no such letter, my
Then
lord, on my part.
Then
But immediately after 2023.
So from 21 to 23 again you sat idle. In 23 he applied for himself.
23, my lord, she didn't apply, my lord.
He applied for himself, we are saying.
And we immediately, my lord, processed it and we responded to it.
Yes. What is your response?
My lord, kindly see. Letter dated 30th of August 2023 at
Yes, please read. What does it say?
Page 67, my lord. We asked him to come for the initial medical examination.
Yes.
He didn't turn up.
No distinction with Maya Bauri. No distinction. We don't know how you are raising an issue of relinquishment. We are waiting for you to address us on that issue.
Well, relinquishment.
Where is the occasion to raise a plea of relinquishment?
Well, I say, well, relinquishment. Why? Why I say?
Yes.
Because it's the definition. It comes
Yes.
from the definition. Because
Let us see how you reconcile that argument with the NCWA.
My lord, NCWA, my lord, if your lordship takes up this, the definition, my first, my lord, clause 9.3.0, provision
Yes.
of employment to dependents.
9.3.0.
3.0. Says provision, may I read, my lord? Fourth page.
So this is the entire scheme governing the claim.
It's an extract, my lord, which is relevant for
Bipartite settlement.
it's a bipartite. Sir. Says, my lord, one employment against death of one what?
9.4.0.
9.3.0 is first. my lord.
3.0.
And thereafter, my lord, my 9.4.0 is for permanently disabled. It's prior to that. 9.3.0, 9.3.1, and 9.3.2.
What is her age? The wife's age?
What, my lord? Present age, my lord.
No, her age on the date of death.
My lord, let me see. $27. $46 or 47 at that time.
46.
46 or 47, my lord.
So she was ineligible for appointment.
She was ineligible. Though in the affidavit she declares that now she is 47.
Where?
In the affidavit portion. Page 29.
So how do you, from where are you gathering that age?
Well, I'm gathering from the service excerpts, which is at page 46.
He is saying she is 29 years old.
She is saying that 47 years and on the date of filing, that is on 12th date of December 2024, page 44. But the service excerpt says something different, my lord. Service excerpt is at page 46. Nine.
So she is 18 years in which year?
My lord, if you thought fit, kindly turns to the next page. It was prepared in 83, some like
83.
83.
What is the date of this document?
Next page, my lord. It appears to be 80. It appears to be 93 or 80. Cannot be 90. The original document. This is the original.
The husband's name is Raghu. Was Raghu.
Whose name, my lord?
The deceased.
Deceased, my lord. No, this is Raghu is the father of the deceased.
So what is the name of the deceased?
This is this man of Shadan Dhangar.
What is, you see, there is a date on the right side at page 46 above date of birth, where it says date of birth at page 46.
Yes, it's
So is
written
this the date of this document?
29.
Is it the date of the document?
Well, I'm not sure, my lord. But next page, it appears that it's of 83.
83, yes, that we have seen. But that
That's
whether
what-
that document is part of this, we don't know.
Yes, this is the continuation. Because it's an
Difficult to
addition
say.
sheet says. But however, she has claimed for this MMCC, my lord.
What is the date of this document? You have an exit.
Date of?
This document at page 46.
This is date of 1989, possibly.
So if
Because that
89, she was 18 years, then how can she be?
Actually, my lord, there is no date, my lord.
Huh?
83.
There is no date.
So in 2009, she would be 38. And in 2017,
46.
she would be no 49.
2009, she's 38, my lord. 2017 means 8 years to be added. So 38 plus 8, my lord.
47. That's what he said. 47. That is probably why she didn't apply for appointment.
My lord?
Probably that is why she did not apply for appointment,
The
because she
affidavit portion she has written, now she's 47. My lord, I'm not.
must be an illiterate person with those. So she was not eligible for appointment.
She was not eligible.
Because even if we go by this document, which is your document, she was more than 45 years on the date of demise. So there is no question of her taking any appointment.
If the date is taken as 83.
Yes.
Date is taken as 83.
It is not your stand that she was eligible. You have not said anywhere that she was eligible.
Because we have not filed any affidavit in opposition there.
In the single judge, you have not filed.
There was no scope for that. My lord, I am not also paying here also that let me file, because the lady my lord, concerned, my lord, let her have the, my lord, but my stand today before your lord. Let her have
So
the
this fact that she was 18 years in 89 is not in dispute.
89.
It will have a relevant bearing, because you say she has relinquished. How can she relinquish something which she is not entitled to?
No, my lord, why? Because MMCC, my lord, there are also judgments, my lord. Because what is the scheme? That's why, my lord, I have given the scheme. So lordship kindly takes up clause 9.5.
Yes.
Which governs the female dependence case.
Yes.
It says they have the option, female dependents have the option either to have employment or to have MMCC. But in case they cross, if she crosses the age of 45, then only MMCC is the option. But
No.
it's not that. No, my lord, kindly see the scheme, my lord.
Yes, you are referring to 9.5.0.
9.5.
Yes.
9.5.0. My lord, kindly see. 1, 2, my lord. Clause 2. In case of death, total permanent disablement due to cause other than mine accident. This is not a case of mine accident. And medical unfitness under clause 9.4.0, if the female dependent is below the age of 45 years, she will have the option either to accept the monetary compensation of rupees 3,000 per month or employment. Thereafter, my lord, in case the female dependent is above 45 years of age, she will be entitled only to monetary compensation and not to employment.
What is the big declaration? When she is not entitled, how can she claim an appointment?
Why
That does not mean the other dependent will not get.
When the Supreme Court
She will not get. That is what we said. She was ineligible.
Because MMCC and employment are at par. Because they are at par. One is the alternate.
Even if she is below 45, she will not get both. She will only have an option.
Option.
Once she crosses 45, that option goes.
No, then
What is the
she has
difference?
the option to get MMCC.
No, she doesn't have any other option but to get MMCC.
Kindly come to the, my lord, kindly come to the next line.
Sir, we understand what you are trying to make out.
No, I am making out my only from the NCWA, not from my-
Yes, what you are trying to say is that after she has crossed 45, she does not have any option.
No, I'm not saying that.
Then?
What I'm saying, my lord, as per the scheme, my lord,
Yes.
till 45, she has the option either employment or MMCC.
And after 45?
Only MMCC.
That's what we are saying, that after 45, she has no option. You said no.
She
So
has
that is
the-
precisely what you are saying.
She has
So that is
only get-
nothing conferred by the scheme.
Yes.
Because the moment she crosses the eligibility for appointment, it is more than obvious and clear as daylight that option is gone. So for herself, she will have only one option, that is MMCC.
Yes.
But that does not mean that the other dependents will not have an option for
I'm
appointment.
also running not that case.
So therefore, what is the big thing that you are pointing out from 95.5.0? Nothing.
What I intended to say, my lord, before your lordship is this, because I say that MMCC is in lieu of employment. Always.
Who is not? Who is saying not?
MMCC, if
Who
that be
says
so,
no to this?
so it is to be read from clause 9 point, because it starts from clause 9.3.0, which says employment, only one employment is to be provided against.
These are not facts. These are not things in issue.
My lord,
The issue is the date from which she is to get it.
that's why, my lord.
That is all.
I am trying to impress upon your lordship, my lord.
No,
saying
those
all
are
these
irrelevant things. We need not go into that.
That
the judgment is pinching you only because the date from which it has been
Yes,
granted.
it's only on that.
Only on that,
Only on
nothing
that.
else.
Nothing else. my
Now,
lord.
therefore, we said how you distinguish with from Maya Bori. You are not saying anything.
My lord, I have given, my lord, what I say, my lord, it's not an universal rule that always it is to be given from the date of death.
Who is saying?
So, my lord,
Who says
if
so?
that be so, my lord,
Does the judgment say that in all cases it has to be given?
my lord, if that be so, it is a single judge's bench, honorable single judge's bench order, my lord. So I say, my lord, now here in this case, in the fact,
Tell us whether that judgment has been implemented or not.
yes, that judgment has been implemented.
You have given it to her.
It's to be, my lord.
Yes. No, maybe we don't know whether you are still pursuing it. Therefore, we are.
I think, my lord, SLP has been preferred. I don't think so, my lord.
No, you don't think so, and you know so are two different things.
Yes,
Therefore,
my lord, two different things.
Yes.
Two different things.
So therefore, we are
Take
asking.
any comment from me on that issue, my lord. Then.
So therefore, it is your stand that it is your instruction that it has been implemented.
No, I am saying, my lord, right now from the query made by your lordship, my lord, on the query, my lord, I don't have the knowledge. Now I rectify myself, my lord. Kindly pardon me. I don't have the knowledge.
So tell us only that much. Tell us only that much. Yes, take down.
I have filed another appeal
Why you are not paying that?
My lord, that
Since
has not been paid, my
2024.
lord. I will take the instruction also, but that is to be paid, my lord.
That should be paid.
At least. But I think, my lord, if there is any document required, I will tell my lord the authority to ask for the document and
An issue is raised by the appellant of APO
May be placed on the same day, my lord.
list on 9th as jointly paid list on 9th. Any admissible dues to be paid?
Yes,
No,
my
no,
lord.
in my case, 25% order, I'm agree, 75% orders and in my favor. Whatever happened over there, they asked for NMCC after 12 years. Now Supreme Court came up with a order.
No, we are asking you, is there any amount of admissible payment which is admitted on your part which is to be paid? No.
They are saying, my lord, that this amount has to be paid from the 3 years prior to the filing of the writ
For
application.
Supreme Court,
So let they pay
my
that amount.
argument would be, my lord, kindly grant only 3 years preceding, not from the date of death,
So
because of
therefore,
the delay.
so to that extent, it is
Yes.
admissible.
Yes.
To
So,
that extent, 3 years, last 3 years is
so
admissible.
therefore, in the meantime, you give her that money. Why that is being withheld? What is the justification?
Kindly
We
that
take
order.
instruction, my lord.
But kindly that
We'll record the order. Yes. You take instructions and get it processed. Call the next case.
Item number 5,
6 and 7.
6 and 7.
6 and 7.
6 and 5 will time for
6 and 7.
item number 6 and 7.
Give the file.
followed by Mayabawari, same order, my lord.
When did she apply?
My lord,
You are counting
she
three.
claimed that she had applied on 6/9/2013, but we have never received any document. Thereafter, she applied on 27/10/2024, after 11 years of hibernation. So what has fallen from Supreme Court?
No, we are not hearing the matter. So in 24, she has applied. In 24, she has applied. That is your case, subject to whatever have to be decided by.
They are saying, my lord, they are agreeable to pay 3 years prior to filing of the writ application.
We are not agreeable. That's what Supreme Court said. I said I will take instruction from ECL whether ECL is agreeable to pay the amount.
So what was your case before the single judge? Let us see.
That is their memo, my lord. In the memo also.
File is before your lordship. The order is at page 99 of the stay application. Or in the memo.
No, we are looking at the memo.
Round 8, my lord.
Let it come on 9 as jointly played list on 9.
In the
We will get that information whether they have implemented the judgment or not. If it has been implemented, then there is nothing to await.
And my lord, in the meantime, let them at least, my lord, pay some amount to the.
We would have, if you had not delayed 12 years, we might have. Yes, call the next case.
Item number 5.
Lord, for the appellants, Lord, we were sincerely under the impression that the matter will today be adjourned at the instance of the respondents.
Which matter?
Item number 5.
Item number 5, Worship.
You were under impression that it would be adjourned.
On the instance of the respondents, that was what we were informed of.
I'm for the respondent.
Whatever he informs you is binding on us.
No.
Then let us see what is it. How can you gather such an impression just because he's asked you? Are you appearing or somebody else?
I am appearing. I am being led by Mr. Shomo Mujumdar. Since they told us
So they
this,
had
that is
taken
why-
consent for an adjournment.
Your Lordship so pleases, I can start with the matter, but
If you are ready, we can. If you don't want, we have given consent as you like.
let it be taken up on the next day. That will probably be best.
Just give us a brief background. What
Yes,
is
I
the
will.
issue?
So, my lord, the writ petitioners who are respondents before your lordships today are all employees of West Bengal Labour Welfare Board, which is a statutory board under a statute. Now, my lord, they have retired from their service and they get ad hoc pension. This ad hoc pension they get in terms of the decisions of the board. They had retired with their pay scale which they were drawing, and on that they are given an ad hoc pension on their last pay drawn. They came before this honorable court through the writ petition claiming that firstly, DCRB rules, death cum retirement benefit rules be framed for them. That was the first prayer. And the second prayer was till the time such rules are framed, they be allowed the pension at par with the other state government employees. Their contention was on the basis of section 18 of the act whereby the Labour Welfare Board has been created. They say that section 18 of the act enjoins it that rules may be framed, and till the rules are framed, they should get benefits in accordance with the state government employees. Though it does not mention the word pension, we have our arguments on that. So, my lord, they approach this honorable court with those prayers. First, frame DCRB rules for us. Second, till it is framed, let us enjoy not ad hoc pension, but pension at the rate of state government employees. That was their prayer. Now, my lord, why they are not getting pension in accordance with, my lord, or at par with the employees of the state government rests on, my lord, two notifications which they had relied on. They had, my lord, placed those notifications before this honorable court. Number one, my lord, is the notification of the finance department whereby, my lord, the revision of pay was, my lord, implemented for everybody. Now, my lord, in accordance with that, my lord, the labor department also, my lord, issued another notification whereby all other benefits of the revision of pay were given to the present employees of the board, of course. But, my lord, one clause, it said the pensionary benefits to employees of the West Bengal Labour Welfare Board will be given effect after finalization of the DCRB rules. DCRB rules admittedly has not yet been finalized. So, they are enjoying ad hoc pension in terms of the decisions of the board. Now, my lord, this is where they face prejudice. This is the source and the root of the prejudice they face. We will be placing it before your lordships that despite knowing this, despite placing it before the court, once they fail or neglect to challenge this notification, their writ petition should have failed. My lords, my lord, are well aware of the trite law which has been settled by repeatedly by your lordships as also the Honorable Supreme Court that prayers should be there to get relief. Unless prayers are made and pleadings are also made, the courts must not embark on the journey of giving reliefs on prayers which have not been made. So, if they are aggrieved, that will be in fact our first point of attack. If they are aggrieved by an executive order and the consequence thereof, they should have had challenged that and asked for it to be set aside. The moment they fail to challenge it and ask for setting aside of that, the honorable single judge was not justified in giving or granting them the relief which were beyond the prayers.
What was the prayer in the writ petition?
Yes, my lords will kindly come to the prayers which my lords will file. We have filed paper books at page paper book page 28, page 34 of the paper books.
Page 32.
Page 32 of the paper book. The prayers are, my lord, two folds. Lord, may I place the prayers, my lord? First prayer is a writ of and in the nature of mandamus be issued, thereby directing the respondents to frame a death cum retirement benefit rules for the employees of the West Bengal Labour Welfare Board within a time-bound period, my lord. Your lordships may also determine, my lord, how far they can ask for these prayers. But in B, they had asked for a writ of in the nature of mandamus, commanding the respondent authority to allow the benefit of 6th Pay Commission to the petitioners in accordance with the section 18(2) of the West Bengal Labour Welfare Fund Act 1973 till the finalization of the DCRB rules for the petitioners. These are the only two material prayers. The rest of the prayers are, my lord, certiorari and, my lord, rule nisi and, my lord, omnibus prayer.
And where is that second decision that
Yes, my lord. The second decision your lordships will find at page 145, the second volume of the paper book, my lord. Page 145, second volume of paper book. But my lord, before your lordships take that up, if your lordships are pleased to take up page 136 of volume 2 once, because that is the source whereby, my lord, revision of pay was allowed to, my lord, the petitioners, to, my lord, the employees of the state. Yes. So, my lord, it is at page 136, 136, volume 2 of the paper book, the first notification. It is of, my lord, 29th of November 2019. Has your lordship, my lord, got it? My lord, this is, sorry. Yes, my lord, the type copy your lordships will find, the better type copy at, my lord, the next page, 136A. My lords may also refer to that. So, my lord, hereby, my lord, the revision of pay was given effect to by the, my lord, my lord, finance department. Retirement benefits. Retirement benefits. My lord, may come to, my lord, the relevant portion at page 138. Retirement benefits. My lord, clause C may I place there from. Employees who are now enjoying pension. Employees who are not.
We were waiting for you to come to that.
My lord?
We were waiting for you to come to that. How can one read this document? It is not legible and the type
The type
copy.
copy is there. And the
Please
next
read
page.
from the type copy.
Yes, ma'am.
We have seen the type copy.
Benefits C. Employees who are now enjoying pension. Arey bhai.
Yes.
That is why.
Got it?
That is why. I understand, my lord.
Anyway, we get a sense of what it is saying.
Yes. My lord will also find, my lord,
Employees who are now enjoying pension broadly at par with state government employees, their pensionary benefits, including family pension, will be revised.
Yes.
Mutatis mutandis in terms of FD number so and so.
Yes.
This is what it says.
So, my lord, what happens in West Bengal Labour Welfare Board, to give a context to your lordship, is the last pay drawn is the basis of calculation of the ad hoc pension which are allowed to the retired employees.
What is this who are now enjoying pension broadly at par with the state government?
Yes.
What does it mean?
It means, my lord, employees who are now enjoying pension broadly at par with the state government.
Is there a set of employees who are getting the pension benefit within the board itself?
Yes.
So there are two classes of employees.
The classes of employees, my lord, there are two classes of employees in the board itself. One is appointed by the state directly. There are also, my lord, employees who are appointed by the board directly. So, my lord, they are the employees, they claim to be the employees.
Now we have understood. So the composition is twofold. One is who have been taken from the state services, because you cannot take them by altering their conditions to their disadvantage. They are continuing with pension. Those whom you have appointed directly, you say that we'll take a decision.
And section 18, which is the basis of their claim, relates to those employees who are appointed by board.
Where is section 18?
Yes, section 18. My lord, we have handed over, my lord, the copies on the previous occasion of the act.
You have given us copies.
Yes, these were previously handed over
to
the coordinate.
if it is in the file.
আমার brief আছে। Lords, I have handed over, my lord, copies for your lordships, both of your lordships, my lord.
So what is there in 18.2?
Yes. So, my lord, 18.2 says that the board shall, with the approval of the state
So we can
government.
refer to this?
Yes, my lord. I am also referring to the copy of that
Give him
same
back
thing.
his-
my lord. Yes. Section 18, my lord, if I may place from the beginning itself, the board shall appoint such number of officers and other employees as may be necessary for carrying out its function under this act. The board shall appoint. 2 says the board shall, with the approval of the state government, make regulations regarding the method of recruitment, pay and allowances and all other conditions of service of the members of its staff appointed under this section, provided that until regulations are so made, the conditions of service of such
Yes,
staff shall be covered.
what is the meaning of conditions of service?
Yes, my lord. This we had, I understand, my lord, your lordships, my lord, are indicating is that pension is also a condition of service. So, my lord, it was also argued before the, my lord, the learned, before the honorable single judge, that 18 must be read in light of 17.
Yes. So what is there in 17?
Yes.
No statutory provision is to be considered in isolation.
That
So
was
what
one
is-
of the grounds which the
What
learned
is there in
advocate-
17 which
17 says that, my lord, the
which
board shall-
alters the meaning of the expression conditions of service?
Yes. My lord may take up, my lord, 17, my lord, may I place? The board shall take over and employ such of the existing staff under the control of the Labour Commissioner, West Bengal, as the state government may direct, and every person so taken over and employed shall be subject to the provisions of this Act and the rules made thereunder, provided that during the period of such employment, all matters relating to pay, leave, allowances, pensions, provident fund, and all other conditions of service of the said staff shall be regulated by the rules of the state government from time to time in force, for the time being in force, or such other rules as may from time to time be made by the state government. My lord, while enumerating, it says specifically pensions. The case which we sought to made out before the, my lord, learned single judges, that term pension is, my lord, consciously have been omitted in
Therefore,
section
we
18.
asked you a question,
Yes.
sir. What is the meaning of the expression conditions of service? It is a well-determined expression by now by decisions of the
Yes.
apex court.
My lord, conditions of service, my lord, has been held to, my lord, there is no doubt about it, has been held to include pensions also. But, my lord, we sought for, my lord, to make out this case before the learned single judge also,
Yes.
that if read in light of section 17, where, my lord, it has been consciously placed, and in 18, where it has been consciously omitted.
So you are arguing causes or misses?
My lords?
You are arguing, yes.
Yes. Sir,
They wanted time, but we asked him to just introduce the matter therefore.
The issues are not very short but not tricky insofar as we are concerned. Now,
Yes.
interpretation of this particular provision in the statute. Secondly, is the mode of appointment of these persons. Apropos being holders of sanctioned posts. Now, no doubt, in pension can be a condition of service.
Can be.
Can be. Of course, not judicially pronounced. But not in so far as conditions of service are concerned, like the central government service, in state government service also there are DCRB rules, death cum retirement benefit rules, but which separately lay down the eligibility conditions and other conditions which are incident to such service. It is not as a matter of course. An employee who has put in 5 years of service may not be eligible for pension.
That is correct.
So not
one service may be without pension altogether.
Right.
That is also a possibility and legally sustainable.
Now, yeah. Now the question is not whether it was really a case of granting en bloc.
We have not gone through the order of the Honorable Single Judge by now, but if reliance is placed on 18.2, then perhaps we'll see how you can distinguish.
When the Honorable Single Judge has only proceeded on the basis of the appointment and not the regulations in 18. It will be framed. Appointment of staff by board. The board shall appoint such number of officers and other employees as may be necessary for carrying out its functions under this Act. But there may be very many categories of employees. Suppose for the purpose of an exigency, not a staff is appointed for a period of 6 months or a contractually for a period of 3 years. That's not the enabling provision conferred on the board to appoint staff. Then comes not the board shall, with the approval of the state government, make regulations regarding the method of recruitment, pay and allowances, and all other conditions of service of the members of its staff appointed under this section. So this is really two which should be read before one.
So the statutory mandate of 2 has not been complied till date. Therefore, the statute says if this is not done, what is to be done?
Now, please see the controlling point, or not the exception, not proviso is an exception to the main provision. Provided that until regulations are so made, the conditions or service of such staff shall be governed by the rules made by the state government in this behalf.
So this section gives you two options.
Yes.
One, to go for framing of regulations. If you don't, then state
Interim management is method of recruitment, pay and allowances, and all other conditions of service of the members.
All other conditions.
Now, shall be governed by the rules made by the state government in this behalf.
Any rule made by the state.
Now, does this rule for condition, please see, conditions or service of such staff shall be governed by the rules made by the state government in this behalf. Now, in the state of West Bengal, we have fortunately a separate rule for retirement.
Yeah, DCRB. That is the rule made by the state government in this behalf.
Now, the conditions of service of such staff shall be governed by the rules made by the state government in this behalf. Till such time, the rules are framed.
Correct. So, till now, there is no dispute that rules have not been framed.
Now, suppose the government does not approve framing of a DCRB rule for this particular board.
Then do it. Who stopped you?
Not in the interregnum, was it incumbent or is it incumbent that these employees whose mode of recruitment is questionable, not whose appointment beyond sanction strength or without being appointed on sanction strength is questionable, which has not been tested.
You are not paying them ad hoc pension.
Ad hoc pension we are paying because of the interim arrangement.
Then what this?
Number two, grant them in terms of the rules of the state government in this behalf. That's where we are stuck.
So it is only that point which is you are saying whether it will include a pension or not.
Yes.
Is it your case that apart from pension, there is a departure with the rules made by the state government in this behalf regarding the other conditions of service of the employees? Are you paying everything at par with state government, or is there a distinction. consistently maintained?
Constant.
Where? What have you said about that?
No, they are not getting pay in terms of the state government employees, number one.
They have a separate scale. From where this scale has come?
No, it's contractually fixed. But more or less like the state government employees, more or less.
No. See, either these are facts specifically pleaded or these are facts not specific.
These are on record.
These are on record. So there are other distinguishing features also.
Not we have annexed not through that application to produce additional evidence, the mode of recruitment of these persons.
That's not an issue now. They have retired, they are getting ad hoc pension. How can you now make a collateral attack on their initial entry?
I'm not trying to upset not the benefit of service which they have rendered in the meantime.
No, in fact, you would be stopped.
No, that's right.
A collateral attack, you cannot now go to the root of their appointment.
Only for the purpose of showing not what was the necessary intendment of 18.
Yes. When do you want?
Lordship, the West Bengal Labour Welfare Board Act, Your Lordship. It was
No,
framed in
we are fixing it
1974.
for hearing.
Yes, Your Lordship.
We are fixing it for hearing. When do you want? We are asking. Come with all the judgments, everything will conclude the matter. Give us a date in the next month, any date. Second, third week, maybe third week would be better. We have fixed too many cases in first and second week.
There is no the third week of January, Lordship. This needs hearing. 3rd week of January.
20th?
30th.
20.
Very well, Lordship. 20th.
The old matter. The old matters. Thursday can cover. So it has to be a Thursday. As per the allocation of business printed on my list, on our list, then it will be 29th.
29th. Very well, Lordship.
29th is Thursday.
It by the top, Your Lordship.
All right with you, Mr. Majumdar?
Fine.
Yes. List as list.
For the appellant, Your Lordship.
Number 1. The order of the Honorable Single Judge, in our opinion, requires no interference insofar as its conclusion regarding non-maintainability of the writ petition for issuance of mandamus against respondent number 2.
Your Lordship's only one humble prayer if the cost has been set aside, my lord.
That we should have read. We, however, interfere with the order of the Honorable Single Judge to the extent costs have been awarded and set aside the order of the Honorable Single Judge only insofar as cost 10,000 was imposed.
Grateful, my lord.
We are of the opinion that the petitioner within bracket widow should not be saddled with such costs.
Grateful, Your Lordship.
And now 41.
41, Lordship, I am for the appellant, Lordship. That is the matter, Lordship. The librarian of the Polytechnic colleges filed this application
State Administrative Tribunal in the year of 2005. On that occasion, the order was passed by the tribunal, and that order was thereafter the order was passed to the principal secretary to pass a reasoned order in this matter, and the reasoned order was passed. That was order again challenged for the state tribunal, and that was again against the applicant. That's why application before your lordship. Lordship, the order at page 190.
Reasoned order for which benefit? For what?
We are the librarian in the polytechnic colleges. Our salary should be fixed as per the librarian of the college life. That is the 8,000 to 13,000.
So parity with university.
Yes, parity with the university colleges. That is the Lordship may please to pass come to page 191, the order of the.
Where is the reasoned order passed by the authority?
Page 69. Page 69 is the reasoned order passed on 20th July 2012. May I read the reasoned order? Lordship?
No, let us go through it, please. Yes.
Then the unit order at page 190 and the operate.
So this reasoned order has been sustained by the tribunal.
Yes.
So ultimately, what is wrong with the reasoned order? That has to be seen.
Yes.
So tell us.
Yes. In this regard, Lordship, I am placing only 4 paragraphs of this petition, Lordship. Lordship is to consider the paragraph number 5, 6, 7, and 8
of
this petition, Lordship.
Paragraph
5, 6, 7, and 8
of the petition.
Yes, Lordship. Okay. Page 9. I am placing these paragraphs only, Lordship, that your petitioner states that the librarians of the polytechnics are divided into two distinct categories and are given two different pay scales of 4,500 to 9,700, revised as per ROPA 2009, rupees 7,100 to 37,600, with grade pay of 3,700 scale. Number 10, for those who have bachelor's degree with diploma in library science or its equivalent, and 4,650 to 10,175, revised as per ROPA 2009 of rupees 7,100 to 37,600, with grade pay of 4,100 for those who have master degree with diploma in library science. It is stated that under WBSR, all libraries, including college libraries and university libraries, are clerical staff. The West Bengal Service Rules Part 1 defines that librarians, assistant librarians, and library assistants are all clerical staff, which means that all libraries, irrespective of whether they are polytechnic librarians or college librarians, as per memo number such and such dated 15th of January 2007, the polytechnic librarians are permanent invitee of the academic council. It is stated that the petitioners are also holding similar post status and performing same and similar nature of work like college librarians. All the petitioners are working as librarians in different polytechnics in technical education and training department under Government of West Bengal and getting revised scale number 10 and 11. But the engineering college librarians under technical education and training department under Government of West Bengal and college librarians under education department are getting scale number 16, though they are discharging same and similar nature and same values of work like your petitioner. It is stated that duties and responsibilities of the polytechnic librarians, college librarians, and engineering college librarians are same and similar. Even West Bengal 4th Pay Commission Report Volume 1 Part 2 defines that all polytechnic librarians and college librarians belongs B type category. In spite of that, college librarians and engineering college librarians are given scale number 16 and polytechnic are given scale number 16 and 11, though the readerships quality and states of polytechnic libraries are same as others in category B, which includes polytechnic libraries also. Then Lordship may please to come to page 135. And it's a D, Lordship. That is the WBSR. Only the 2 pages enclosed herewith. That is the middle portions of these page 135, Lordship, who are the members of clerical staff. Appendix number 2. Lordship, may please to consider. Page 135. Appendix number 2, member of clerical staff. These are the office superintendent. That is not necessary. Lordship, may please to turn the next page, page 136. Point number 10. Librarian, assistant librarian, library assistants. All the librarians, WBS, all the librarians, including college librarians, are also clerical staffs. All are the clerical staffs, as per the page 135 of the WBSR. Then, Lordship,
this list of clerical staff is for a particular institute.
They are the polytechnic colleges library.
No, this list that you are reading.
Yes, yes.
At page 135.
This is the West Bengal service.
It is applicable to all services in the state of West Bengal, or it is for a particular institute or organization?
No, for the all service rules. West Bengal service.
How do you say so?
That is the entire rules is not annexed here with that. Is only the 2 pages enclosed here with.
So how you are saying, when you are saying we are asking you?
Then that should be placed before your Lordship for the entire the service rules to be placed before your Lordship.
No, you said that it is, this list is applicable to entire services. So from where you are saying, we are asking you?
Then the entire West Bengal service rules to be placed before your Lordship. In only 2 pages there is only. That's why that cannot.
Then how you said that it is applicable to the entire West Bengal?
Service rules
when you are making such submission, we expect that you have examined it. When we ask you, then you say rule has to be placed. This is no way of making submission. You see appendix 2, what is the heading? Director Administrative Training Institute, Government of West Bengal. This is for that institute.
Yes, Lordship.
Is it for the institute? No. That's what we are saying. For the Administrative Training Institute, it is written there and you are saying it is for the entire West Bengal.
ICT regulation does not applicable there.
That's not, what he is saying is that according to this, all librarians are clerical.
That is for the college librarians and for the polytechnic college.
No, from where do you get that? You read the heading, what it says at 80, at page 135.
Director Administrative Training Institute, Government of West Bengal at Bidhannagar, Salt Lake City.
Yes, this is for that institute. This is the member of clerical staff.
But it is the West Bengal Service Rules, one of the part of the West Bengal Service Rules. That is
We don't know what you are trying to submit. We are unable to understand.
Then I have to place the entire service rules before your Lordship.
No, sir, you said that this is the list. According to this list, all librarians are clerical staff. Which is not correct. This list is for this Administrative Training Institute. How you are applying it to all the services? Make any submission. You are reading something else and submitting something else.
No. That is not the something else, Lordship. That is the same. I have to submit before your Lordship. After placing the entire rules, that should be submitted.
It is for the members of Director Administrative. Where is rule 5.8? Let us see West Bengal Service. You don't have the rule today.
At that moment,
You come with the rule.
yes, Lordship.
No, he's saying under the rule there is some categorization. Unless he comes with the rule, how he can make the submissions. See, what we can gather by now is that there are three kind of institution where librarian is posted. One is polytechnic, another is engineering college, and third is the degree college. Degree colleges and universities. So degree college, university and engineering colleges, they are on par. Whereas the polytechnic librarians are somewhat disadvantaged in terms of pay. They say we are performing the same work, equal pay for equal work. That is their case.
Yes. So what is polytechnic is concerned? Polytechnic.
So what are the points of distinction based on which a different pay scale or equal pay for equal work can be denied? Nargesh Mirza judgment.
So what is university is concerned? College is concerned. So for engineering colleges and degree colleges in India,
AICT.
AICT.
Yes.
But they are not under the AICT. They are not separate rules.
That is all right. They are saying whatever may be the rules. If we are performing the same work, then we should get the same. That is their claim.
But the pay commission also recommended that.
So therefore, we have to see whether pay commission's recommendation is sustainable or not. So what are the points on which a distinction can be drawn? Source of recruitment, qualification. So
Nature of duties, products, so on. What is this concern? Like it is.
So we'll see.
That was shared with the agreement.
They have not filed any affidavit.
Yeah, we have filed an affidavit. No. On 25th of no.
In this case,
Yeah.
We have not been served any opposition. No copy served of us. That is the direction in the year of 2024.
No. Upon 20,
he already filed. Then give him a copy. देखो तो opposition है. हाँ. So today you are filing.
yes, we are.
Then give him a copy. Then give him a copy. Affidavit in opposition filed today. Perhaps Nargesh Mirza judgment is there. Nargesh Mirza judgment on equal pay for equal work.
Nature of
No, in that judgment, that is the leading judgment. Nargesh Mirza, Air India or something.
subsequently 2018 and 19.
No, that is all right. Who is saying? But the point is, if there is a discrimination, therefore, what are the points of distinction? You have to argue. If there is a distinction in the educational qualification, the source of recruitment, the duties performed, then
Duties are the same. I can. Nargesh Misra was the Air India.
perhaps if I remember correctly. Nargesh Mirza, it is regarding that the air hostesses were being paid to different categories. They became above the age. Earlier.
Yeah, India.
70, segment of 70. Then there was no question of sexual equality. So, she has served.
This is absolutely.
She is a female, she will gain, she will not remain as presently. So that is give her
नहीं ये तो judgment नहीं है judgment. May I bring on spot in analysis? Person please to fix the date. Why say? Why say? Why say? How do we go? Great.
Item 42.
none appears for the petitioner, then that AGP is present. Last day when after
Item 43.
Yeah, 43 वाला term for the appeal in petition. The matter is related to the railway go down matter. And the 42 writ petitioners and illegally occupying the 53 railway go down. And the railway issued the notice for escalation of the rent of the go down. Challenging that the writ petition was filed, ultimately there was near about 37 crores dues. What happened in the writ petition? There was a separate land policy for the railway land. How the land will be distributed, how the land rent will be escalated. But in instant case, it is related to the go down. In respect of the go down, the agreement is there, and on the basis of everything will be held by the agreement. But by the trial court, disposed, allowed the writ petition on the basis of the land policy.
Which according to you is not applicable in respect of go down.
Yes, my lord.
Which according to you is not applicable in respect of go down.
Yes. Not applicable. And
For
apart
go
from that,
downs, the rights inter parties has to be determined on the basis of the agreement.
and my lord,
So,
apart,
but you started by saying that they are illegal. So if there is no agreement, then where's the question of,
and my lord, apart from that,
is there any agreement with this person?
yes, yes. There is
Then why you said they are illegal?
there is an agreement, my lord, and in the
Then why did you say they are illegally occupying?
as because, my lord, that they are not paying the rent, my lord. And my lord, notice was already issued, my lord. And apart from that, my lord, most surprising thing is this: on the basis of this agreement, they preferred an application under section 11 of the Arbitration and Conciliation Act for appointment of arbitrator. By this honorable court, arbitrator was appointed, and ultimately, my lord, the award was passed in favor of the railway. Without challenging that award under section 34 of the Arbitration Act, they preferred the writ petition. And my lord, every point was, my lord, elaborately stated in the
They are appearing.
opposition also.
They have appeared.
And my lord, on identical situation, my lord, just my lord, the name of the writ petitioner is different. And in case of a railway go down on identical section 11, thereafter award. And my lord, in that case also, the exclusion of, my lord, the rent, our division bench passed the order. My lord, for a moment, my lord, kindly see, and there is a specific direction of the, my lord, the guideline was issued by the railway board also, that the land policy is a separate policy for the land. That is not applicable for the go down. For a moment, my lord, kindly see the impugned order, my lord. And my lord, that the Bonde Bharat project, my lord, the railway is not, my lord, the failed to introduce, my lord, the more Bonde Bharat train due to the, my lord, the land, my lord. As because this land is also required for preparation of the card set, my lord. For this reason, I have also filed a separate application, my lord, in connection with that. My lord, kindly come to the impugned order, my lord. That is, my lord, at page 330, my lord. That is the last annexure. May I place that, my lord?
Just a minute.
And in turn, my lord, go down has been already declared that is in serious dilapidated condition, and at any time an accident may be happening.
Are the respondents appearing? Are the respondents appearing?
My lord, most unfortunate thing is this, my lord, for last 5 years, this file was not traceable.
The more fortunate thing is that now it has been traced. So where are were they appearing? Earlier have they appeared? We are asking.
As your lordship, my
No,
lord.
have they appeared earlier?
Yes,
Yes, they have appeared.
appeared.
So you can inform the advocate.
They have appeared.
You can inform the advocate, learned advocate. We find the name of one Mrs. Aparna Banerjee.
Mr.
Mr. Parsati Bose was the senior advocate.
Similar matter, my lord, already, my lord, identical. Just name of the petitioner is changed.
No, but in
Notice also, Mr.
it may not be proper to proceed in their absence.
Nivedita Pal was appearing.
Whoever is appearing, please inform
Nivedita Pal.
so that we can proceed with the matter. So this 10% and 7% has been fixed based on the land policy.
Yes, my lord. Matter was disposed of on the in the writ petition also. They are prior also to dispose of the writ petition on the basis of the land policy. But my lord, the land policy is not applicable. Go down for this decision, my lord, the agreement is sufficient. My lord, for a moment, kindly see the land policy, my lord. Kindly that the land policy everywhere stated.
Is any agreement on record?
Yes, my lord.
Is any of the agreement on record?
Yes, agreement is there.
Where is the agreement?
My lord, prior to that, may I see the kindly see the prior, my lord, the writ petition. That is page, my lord. Start from page 77.
See, in absence of respondents,
Just 3-4 pages, my lord, I want to show my lord.
the paper book.
My lord, everything, my lord, I have, my lord, annexed with the stay application.
No, we are asking you to prepare a paper book.
My lord, if your lordship is direct me, my lord, we are bound to, my lord. My lord, one thing, my lord, that land is
become impossible
required,
to look like
my
this.
lord, for Vande Bharat project also, my lord. I have, my lord, filed for this in one application also.
Yes, we are looking at that in December 24. We have
My
filed.
lord, every documents we have annexed with the stay application.
We can't proceed like this. It's impossible. It has to be organized. Just
If your lordship direct me, my lord, we can come back with the submit on application to the learned advocate of the writ petitioner, my lord. Kindly take it, my lord, on the next day, next week, any day, my lord.
no, not this side. Impossible. Now next month. It can't be done in the coming week. Therefore, we are saying, in the meantime, it will only be for your benefit if there is a paper book. It will facilitate consideration. You are saying, look at this page and that page. There are so many. Not possible.
Yes, my lord, that is 330 pages. Is
Yeah,
there.
therefore, we are saying it will become organized. It will help you also. It will help us also. Both of us.
That was short, my lord, long back ago, my lord. One regarding the Vande Bharat project, my lord, I am filing one supplementary, my lord.
Serve on them.
Yes.
The supplementary affidavit is being filed. regarding this date.
Item 44.
This is arising out of contempt. Yes, my lord, no, no, my lord. My lord, the impugned order, my lord, last page, my lord. At page 98, OA number 335 of 2016. 335. Yes, ma'am. On the last occasion, my lord, your lordship was pleased to direct me to bring the judgment passed in WPS number 157 of 1998 and the circular dated 15 1998. Last order is nothing. আপনার কপি আছে শুধু না একটু না না আমি ধরে এখন This judgment was placed before the tribunal. My lord. Was this judgment placed before the tribunal? No, my lord. There was no scope. তো যেগুলো আনতে বলেছিল আমার কাছে আর কপি নেই সমস্যা হয়ে গেছে Tribunal has relied on some decision rendered in the case of Krishna Das Gupta. That has to be considered. Why you have approached, why you have come so late? No, my lord. I retired in the year 2015. I filed OA in the year 2016. You were absorbed in 2007. In the year 2000, my lord, police verification and medical examination was held. In 2000? In 2000, to give appointment in compliance with the order passed by the Honorable Justice N.K. Bhattabgal. But they remained silent in spite of repeated approach and request. That is why we asked you, that is why at the outset we said, Krishna Das Gupta, the tribunal says the facts are similar. There also police verification and medical was done in 2000. But the division bench has disallowed their claim. So, my lord, kindly give me opportunity to bring that judgment mail and to go through the judgment mail. You please see page 4 of the tribunal's order. Yes. Second paragraph. I am not, my lord, on retrospective effect of. Sir, please read before you make your submission. Das Gupta versus State of West Bengal. The division bench of the Honorable High Court at Calcutta dealt with the issue where the petitioner prayed for appointment with retrospective effect for getting pensionary benefits. In the said unreported case, the petitioner rendered service as Tahsil Mohrar for prolonged period of time before absorption in the regular establishment. The police verification of the petitioner of the said case was completed in the year 2000 and appointment in the regular establishment was given in the year 2005. Therefore, we say, and as such, the petitioner claimed for giving effect of the appointment from the date of police verification. So the same thing. Same thing. In the present case, the applicant has made the same prayer of giving effect of appointment from the date of police verification held on March 27, 2000, and the applicant has taken the same plea of inordinate delay in giving appointment. In this case, my lord, I, along with other candidates, my lord, filed the application in the year 1990. My lord, kindly see the judgment, my lord, annexed in the OA application. How that is relevant? Yes, my lord. And in that application also, it was directed by the Honorable Tribunal, Honorable High Court, that you give appointment in phases. You absorb these Tahsil Mohars. But they did not, they gave some candidates of their own pick and choose policy. And how that is relevant? The tribunal is relying on a judgment. My right to appointment was crystallized. The tribunal is relying upon a judgment to distinguish your claim, which it says it is one and the same. Here also you are claiming with effect from police verification. There also he was claiming with effect from police verification. So how the history is relevant? History is relevant, my lord, on the ground there. Then you should get it from 1990. Why not? My lord, Why you have prayed from the date of police verification? Why not? Why didn't you pray from 1990? How that is relevant? You may argue everything.
Seeking minimum pension, my lord. Only 20 months
Correct.
shortfall.
So therefore,
Only 20 months shortfall in that 10 years, my lord.
how you distinguish your case from Krishna Gupta, that is what we are asking you.
My lord, kindly, my lord. My lord, give me one another opportunity.
Not today, come on Thursday.
Yes, ma'am. Yes, yes, ma'am. Much obliged, ma'am. I am grateful, my lord.
We have understood what you are saying, but
Yes, ma'am.
tribunal is relying on a judgment. Let us see what it
My
is.
lord. And on the similar case, my lord, you lost also has passed the judgment just similar to this case, similar situation. Hiralal Ghosh, Alochana Pan, your lordship has fixed that date of judgment on 23rd December. A similar situation. In the similar situation, then it has to be referred to the larger bench. If so, according to me, I beg to be pardoned, my lord.
We will see.
I beg to be pardoned, my lord.
No, why?
Because your lordship only in the similar situations allowed the writ application and giving the reasons.